with the law and with the courts. Roosevelt was trying to see to it that prior decisions of the court were overturned. He was trying to bring in a new order, a new procedure for the law of the land. The corporate United States goes bankrupt. A bankruptcy case was needed on the books to legitimize the fact that the corporate U.S. had already declared bankruptcy. This bankruptcy was effectuated by compact that the corporate several states had with the corporate government corporate capital of the several corporate states. This compact tied the corporate several states to corporate Washington, D.C., the headquarters of the corporation called the United States. Since the United States Corporation, having established its headquarters within the District of Columbia, declared itself to be in the state of bankruptcy, it automatically declared bankruptcy for all its subsidiaries who were effectively connected corporate members, who happened to be the corporate state governments of the Union. The corporate state governments didn't have to vote on the bankruptcy. The bankruptcy automatically became effective by reason of the compact agreement between each of the corporate state governments and the mother corporation. Note: the liberty of using the term mother corporation to communicate the interconnected power of the corporate federal government relative to her associated corporate states has been taken. It is historical knowledge that the original Union states created the federal government. However, for all practical purposes, the federal government has taken control of her creators, the states. She has become a beast out of control for power. She has for her trade names the following: United States, U.S., USA, United States of America, Washington, D.C., District of Columbia, Feds and federal government. She has her own U.S. Army, Navy, Air Force, Marines, Parks, Post Office, etc., etc., etc. Because she is claiming to be bankrupt, she freely gives her land, her personnel, and the money she steals from the Americans via the IRS and her state corporations, to the United Nations, and the international bankers as payment for her debt. The UN and the international bankers use this money and services for various worldwide projects, including war. War is an extremely lucrative business for the bankers of the New World Order. Loans for destruction. Loans for reconstruction. Loans for controlling people in her New World Order. The U.S. Incorporated declares bankruptcy. The corporate U.S. then is the head corporate member, who met at Geneva to decide for all its corporate body members. The corporate representatives of the corporate several states were in attendance. If the states had their own power to declare bankruptcy regardless of whether Washington, D.C. declared bankruptcy or not, then the several states would have been represented at Geneva. The several states of America were not represented. Consequently, whatever Washington, D.C. agreed to at Geneva was passed on automatically, via compact to the several corporate states as a group, association, corporation or as a club member. They all agreed and declared bankruptcy as one government corporate group in 1930. The several states only needed a representative at Geneva by way of the U.S. in Washington, D.C. The delegates of the corporate United States attended the meetings and spoke for the several corporate states as well as for the federal corporate government. And, presto, bankruptcy was declared for all. From 1930 to 1938 the states could not enact any law or decide any case that would go against the federal government. The case had to come down from the federal level so that the states could then rely on the federal decision and use this decision within the states as justification for the bankruptcy process within the states. Uniform Commercial Code emerges as law of the land. Ah, ha, are you beginning to get the picture? By 1938 the corporate federal government had the true bankruptcy case they had been looking for. Now, the bankruptcy that had been declared back in 1930 could be upheld and administered. That's why the Supreme Court had to be stacked and made corrupt from within. The new players on the Supreme Court fully understood that they had to destroy all other case law that had been established prior to 1938. The federal government had to have a case to destroy all precedents, all appearance, and even the statute of law itself. That is, the statutes at large had to be perverted. They finally got their case in Erie versus Tompkins. It was right after that case that the American Law Institute and the National Conference of Commissioners on Uniform State Laws, listed right in the front of the Uniform Commercial Code, began creating the Uniform Commercial Code that is on our backs today. Let us quote directly from the preface of the official text of the Uniform Commercial Code 12th edition. The code was originally approved by its sponsors and the American Bar Association in 1952. And was revised in 1958 to incorporate a number of changes that had been recommended by the New York Law Revision Commission and other agencies. Subsequent amendments that were deemed desirable in light of experience under the code were approved by the Permanent Editorial Board in 1962 and 1966. The above-named groups and associations of private lawyers got together and started working on the Uniform Commercial Code (UCC). It was somewhere between 1938 and 1940, I don't recall, but by the early 40s and during the war, this committee was working to form the UCC and getting it ready to go on the market. The UCC is the Law Merchants Code for the administration of the bankruptcy. The UCC is now the law of the land as far as the courts are concerned. This legal committee of lawyers put everything, negotiable instruments, security, sales, contracts, and the whole mess under the UCC. That's where the uniform word comes from. It means it was uniform from state to state as well as being uniform with the District of Columbia. It doesn't mean you didn't have the uniform instrument laws on the books before this time. It means the laws were not uniform from state to state. By the middle 1960s, every state had passed the UCC into law. The states had no choice but to adopt newly formed Uniform Commercial Code as the law of the land. The states fully understood they had to administrate bankruptcy. Washington, D.C. adopted the Uniform Commercial Code in 1963, just 6 weeks after President John F. Kennedy was killed.